Good morning, Justice. Thank you for granting this interview.
Good morning, Adrian.
Sir, how should the country view this ruling by the tribunal, specifically on the jurisdiction issue?
Well, on the jurisdiction issue, the ruling means that the proceedings will continue on the merits. The Philippines will present its evidence on why the 9-dash lines are void and why certain geologic features are low tide or islands entitled only to 12 nautical miles and not to a 200 nautical mile exclusive economic zone. So in other words, the ruling is what we wanted.
Can we say, sir, that it's a victory on the part of the Philippines?
Yes, it's an initial victory because it's just the preliminary issue on jurisdiction.
Sir, the 7 submissions that the tribunal ruled it has jurisdiction, what's their significance? And some analysts are saying that the 7 other submissions that the tribunal said reserves consideration of its jurisdiction are the most important Philippine submissions. We have the 9-dash line, the China's illegal activities on the disputed waters. Your take on that, Justice?
Well, you must remember that when we filed this case, we didn't want the tribunal to bifurcate the proceedings. In other words, we wanted the tribunal to decide the jurisdiction together with the merits. But because China submitted a position paper without participating, they submitted a position paper on the jurisdictional issues, the tribunal was forced to bifurcate it, to have a separate hearing on the jurisdictional issues, because under their rules of procedure, they have to do that if the issue of jurisdiction is raised by a party. And so we had to go through this jurisdictional hearing, and 7 of the issues, the court said they have jurisdiction, and on the 7, they said we can determine jurisdiction only if we go through the merits. In other words, the jurisdiction issues are so intertwined with the merits that they cannot decide right now. But you have to remember that it was our position that all of this should be decided together. I mean, that was our original position, and it doesn't. It's no big deal that the tribunal said that on 7 issues we reserved. But remember what the principal objections of China to the proceedings were 2: that we raised sovereignty issues, and second, that the issues we raised involve sea boundary delimitation, which China said they will not be subjected to compulsory arbitration. They made a reservation. So these are the 2 substantive objections on jurisdiction. And the court said, the tribunal said, this case does not involve sovereignty issues. It does not involve sea boundary delimitations on all the 15 issues. So their principal objection on jurisdiction, the 2 principal objections by China on the jurisdiction were totally rejected by the court. The fact that the court said on 7 issues we cannot yet rule because it involves factual issues. They have to know the facts, and we have not yet presented the facts. Doesn't mean anything really. We expected that because that was our position from the very start.
Sir, let's go back to the hearing at The Hague in July. You were there, sir. You were part of the Philippine delegation. You observed the entire proceedings, sir. Sir, how was the line of questioning there? And do you think we were able to provide them satisfactory answers?
Yes, I think we answered fully all their questions, orally and in writing. I think that's why we have this kind of a ruling. We got everything we wanted. That portion there, that 7 issues, on 7 issues they deferred, doesn't really mean anything because we expected that.
Sir, we know that the oil exploration at the Recto Bank has been stopped because of the pending arbitration case. Sir, with this ruling on jurisdiction, can we now say that the government can now proceed with it, or if not, when?
No, not yet, because the case has not been finished yet. We have to wait for the outcome. It's still pending.
But sir, once the tribunal has ruled let's say, favoring our position, then we can.
If the tribunal rules that the reed bank belongs to the exclusive economic zone of the Philippines, then of course we have all the right to proceed, because under the law of the sea, we have the exclusive right to exploit our EEZ.
Sir, how about the recent move of the U.S., a U.S. warship sailing within the 12 nautical miles of Subi Reef? Sir, how does this affect our case, and will this put pressure on China to finally participate in the arbitration case?
Well, the sail-by the U.S. Navy was pursuant to their freedom of navigation operations, because the U.S. has always held that beyond the territorial sea, there's freedom of navigation for commercial vessels as well as military vessels, without the sovereign of these vessels asking for permission from the coastal state. That has always been their position, and that is the majority view, the overwhelming view in all jurisprudence. Majority of the overwhelming majority of countries follow that position. A small group of countries, not more than 20, including China, follow the position that beyond the territorial sea, but within the EEZ, warships will have to ask permission for those warships to sail. But recently, China sent its navy to the Mediterranean for naval drills in the Mediterranean Sea, together with Russia. And in the Mediterranean Sea, there are no high seas. They're all overlapping exclusive economic zones. And China did not seek permission from the coastal state. So they are now inconsistent. And China also recently sailed through with their vessels, with their warships, through the EEZ and territorial sea of the U.S. in the allusions of Alaska. So without permission from the U.S., and the U.S. just allowed it because that is the position of the U.S. So China is saying that the foreign vessels, military vessels, cannot sail in our EEZ without permission, but they're doing the opposite now. So I think finally they will agree to that, because what will you do with your blue water navy if you cannot sail through the EEZs of coastal countries? I mean, you have to ask permission every time you sail through the EEZs, and they're all over the world. So I think eventually China will adopt the position of the U.S. That's what happened during the Cold War, when the USSR also did not allow American warships to sail through their EEZ. But when they had a blue water navy, they changed their position. So I think that's just temporary. That's just temporary. China will eventually adopt the same view as the U.S. because they have expensive warships, and those warships cannot sail through around the world, because they have to pass through many exclusive economic zones. So the U.S. position is separate from our position. Our position is that within our EEZ, we have exclusive right to exploit our natural resources. The U.S. operations have nothing to do with that.
Yeah, good thing, sir, you pointed out, because U.S. is maintaining that it's not taking any side, particularly that of the Philippines when they sent that warship.
Yeah, it was not to favor us. It was not to support our position, because they have a different issue with China. Although there is some convergence, but that convergence will disappear the moment China adopts the U.S. position. Because as far as the exploitation of the natural resources within our EEZ, the U.S. is not saying anything. They're just saying, we support the Philippine approach to bring this to a peaceful resolution through arbitration. That is what they're saying.
Sir, you've mentioned earlier about sovereignty. We know that the arbitration case only settles the maritime entitlements. What should the Philippines and other claimant parties do in order for that sovereignty question be resolved finally?
Well, as you know, there are two issues in the South China Sea dispute. There's the territorial dispute and the maritime dispute. On the maritime dispute, all the parties have signed the United Nations Convention on the Law of the Sea, and there is a compulsory dispute settlement mechanism. That's why we can sue China. when it comes to the territorial dispute, there is no agreement among the countries that the dispute on territory will be submitted to compulsory arbitration. For every territorial dispute, the parties must agree to submit it to compulsory arbitration before the ICJ or any other arbitral body. China refuses to submit this to arbitration, the territorial dispute, so we cannot force China. Now, the ideal thing is for ASEAN to adopt an agreement that all territorial disputes should be submitted to arbitration and invite China to join that agreement so that the territorial dispute in the practice will be submitted to resolution by an arbitral body. It could be the ICJ. There is precedence to this. Of course, you have the Pact of Bogota in Latin America, where all the countries in Latin America have agreed that all territorial and maritime disputes should be submitted to compulsory arbitration. That's why you don't see border wars anymore in Latin America, because before they signed the Pact of Bogota, they were always fighting each other because of their border problems. They claim that you're encroaching on our territory. So there would always be perpetual border wars because of course, their borders were arbitrarily drawn by the colonial powers at that time. So they devised this mechanism, the Pact of Bogota. Now, we have ASEAN integration now. Economically, we plan to be a union. But there's one missing component, that the territorial dispute should be submitted to arbitration so that countries within ASEAN don't go to war. So I think we have to move for this and invite the other countries in Asia to agree so that there will be no territorial wars anymore. I mean, we submit to the rule of law.
So is it correct to say that it is the COC that we're pushing?
No. The COC is different. The Code of Conduct says what it is. It is a code for regulating conduct, conduct at sea, so that you don't go to fight each other when you bump into the sea. It's a code of good behavior in sea so that you will not go to war, a shooting war. It does not settle the dispute. That is not a dispute settlement mechanism. That is a mechanism to regulate conduct at sea. So the dispute will still continue as to who owns the maritime zones. There is a dispute settlement mechanism under UNCLOS. We don't have to reinvent that. The Code of Conduct will not involve a dispute settlement mechanism on maritime zones. That's already in the UNCLOS, and we don't want it to be changed. The Code of Conduct that we want China to sign is a code on behavior at sea.
Sir, all this issue on the West, on the South China Sea, the West Philippine Sea, do you think this is just a battle or a fight over resources, or this is China asserting itself as a world superpower?
Well, definitely China wants all the resources in the South China Sea. They want all the fish, all the oil and gas. That's why when we tried to bid out internationally areas 3 and 4 in the reed bank, they sent us a note verbal, and they said, we own areas 3 and 4 in the reed bank. We own, in fact, the entire reed bank. That's their position. So it's a fight over resources, over fishery, because China adopted a fisheries regulation that you cannot fish in the South China Sea without our permission. So it's a fight over resources. Of course, if you control the resources in the South China Sea, then you influence a lot of countries around the South China Sea.
And is it correct, sir, that if China maintains control over the South China Sea, what's stopping them from moving to other bodies of water or to other territories?
Well, there are speculations that after securing the South China Sea, they will move beyond the first island chain in the Western Pacific. We do not know if they will do that, but that seems to be the direction. But if they do that, if they can control the South China Sea economically and militarily, then there will be no law of the sea anymore. There will be no UNCLOS. That's why we went to the tribunal and asked the tribunal to apply the law of the sea in the South China Sea. So I expect that the tribunal will say China cannot claim the entire South China Sea. They will be limited to what UNCLOS allows them, 200 nautical miles from their coastline. And I think that decision will be supported by the world. So China will be isolated here.
So let's say we win in the arbitration case. The bigger question is, how do we make China honor that ruling?
Well, China already said that they will ignore any adverse ruling. Of course, that's their initial position. But once we get that ruling that the 9-dash lines are void, we will go to the international community to support us, help us convince China. And of course, China wants to be seen as a responsible member of the civilized community of nations. They want to show that they follow international law. And China needs the world to survive. It needs to export to survive. It needs to import to survive. And they cannot just ignore world opinion. They want the world to join them in their maritime Silk Road, in their One Belt, One Road over Asia and the European landmass. But why will countries join them when they encroach, invade on the maritime zones of coastal states? So they have to follow international norms if they want the other states to cooperate with them.
Sir, it's stated in the press release of the arbitration court that we expect a ruling by 2016. Sir, when exactly do we see that?
Well, we expect it by not later than mid-2016 because normally it takes the tribunal 4 to 6 months from the time the case is submitted for decision. And it will be submitted for decision by end of this month.
Sir, lastly, sir, do you think our legal team at The Hague will be ready enough to defend our claims, especially now when we go to the merits of the case?
Yes, they've been ready for some time already. And I think I am completely confident that they will do a very good job, an outstanding job, in fact, in defending our position.
Just as any final words, what should we anticipate, what should we expect during the merits part of the case?
Well, I think what we should be doing is to explain to the world our position, so that when the decision comes, they will understand what it means and they will support the decision of the tribunal.
But sir, sorry, sir. Do you think the support of the G7, the ASEAN, do you think that's enough already, or do we need more pressure?
Well, the G7 came out with a declaration that they expect the parties, China and the Philippines, to abide by the decision of the tribunal. The EU came out with a declaration that they support the arbitration approach of the Philippines as a peaceful settlement of dispute. In fact, that is the statement of all the countries, because that's part of the Charter of the UN. Arbitration is a peaceful settlement of dispute. That's expressly enshrined in the UN Charter. And once there is a ruling, that ruling becomes part of international law. And that has to be followed by all civilized nations.